is not confined to elimination of filth, stench, and unhealthy places. It is ample to lay out zones where family values, youth values, and the blessings of quiet seclusion and clean air make the area a sanctuary for people. Well, those were the words of Justice William O. Douglas in 1974 in Village of Belterre versus Boras, where the, at that point, thrice married justice thought it was fine to lecture the rest of us on what we can do with our property rights and family values. That is considered the high watermark of modern zoning, the state's power to tell you what you can do on your own property, even when you're not doing anything wrong. And we at the Institute for Justice have always thought differently about property rights. And so recently we decided it was time to do something about it. And so we have a new project that we're going to talk about today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on a Thursday, July 11th, 2024, and we got a little different twist today on Short Circuit. We're going to be talking about a recent couple of cases, couple of controversies, but they won't be in federal court. They will be in state court, and to a large extent, that is because most zoning litigation happens in state court, although you do get the odd case in federal court as well. Joining me today to announce this new initiative that we have at IJ and to talk about these cases are my friends, Ari Bargil and Joe Gay. So welcome to both of you.
Thank you, Anthony.
Thanks, Anthony.
So, Ari, zoning justice is what we're calling this thing. What is the injustice in zoning that our audience should know about?
The injustice in zoning is the fact that the way that the government has divided us, in fact, literally segregated us into different areas, has made us less free, less prosperous, and even less kind. As a result of these arbitrary lines on maps that government draws for us, it's become exponentially harder and significantly more expensive to find and construct housing, start a business, or even help the needy when government dictates to you both how and where you may do those things. So IJ Zoning Justice Project is designed to protect and promote the freedom to possess property and to use it peacefully and productively, just like our founders intended. We'll do that through strategic litigation, advocacy, and legislative work in the hopes of striking down unnecessary and irrational barriers to the peaceful and productive use of property.
Right. And in some ways, this is not a new thing at IJ. We've fought for property rights for decades, and we've even done cases involving zoning for a long time. I filed a case over 10 years ago now that was basically a zoning challenge. But it seems like over the years, the world has caught up to us on what we were already doing. We had a couple years ago our friend Nolan Gray on, who has this great book about zoning and abolishing zoning is what he argues for. We've had a number of other experts over the years talk about zoning, and it seems like kind of the zeitgeist of zoning being a problem has finally turned, and so it's in coupling with that, right, that we now have a full kind of project to tell the rest of America about that zoning is actually unjust in many ways. And so we would like to be part of this solution that is already happening around the country, right? So there's already not just been litigation about zoning pushing back on its contours, but some legislative success. A lot of states and cities, right, have reformed their zoning laws.
That's absolutely right, Anthony. And as you mentioned, this is an area that IJ has been active in for quite some time. And the goal here is to unify some of these things under one common umbrella, as we've identified that localities are especially abusive when it comes to property rights via their zoning powers. So we're taking a targeted approach here, and we're going after these things in a way that IJ is uniquely situated to do. When we talk about things like affordable housing or helping the needy, it's often the case that the loudest voices in the room are calling for additional government intervention. And as we're going to talk about a little bit later today, sometimes the best thing to do, and in our view, the constitutionally appropriate thing to do, is to do away with a lot of the barriers that have made it harder for people to construct affordable housing, made it harder for people to start businesses, and made it near impossible for people to assist the needy and take them in where necessary. So that's IJ's approach. There are obviously a lot of people who are on board with us, but it's exciting for us to be leading in this area, especially given the uniqueness with which we do things.
So most of our cases that you can find collected together at the Zoning Justice page that we'll put a link up in the show notes. Most of our cases, of course, are about a silly law that is restricting a property owner from doing more things that would be better for him and for the common good with his property. So whether that's adding an additional unit to a house or opening a new business or whatever it is. But as I said before, some legislators have actually cottoned on to this, and some states and cities are reforming their laws. And Montana was one of those. This is a very bipartisan thing across the country. You have Democrats doing this, you have Republicans doing this, and Montana, which has a pretty Republican legislature, but actually the Democrats were part of this too, is they reformed their zoning laws. So it is easier now to have housing, which is probably a good thing, I think. In Montana, you can now have an ADU, basically a mother-in-law house, or you can add an additional unit onto your single-family home in most of Montana where you couldn't before. But that didn't sit right with everyone. And so this is a case where we are weighing in on a situation with an amicus brief that Joe's going to talk to you about, where we're actually on the side of the government that's trying to do something right, and yet for some reason that rubs some people the wrong way.
Yep, that's right, Anthony. And the case is called Montanans Against Irresponsible Densification, LLC versus Montana. They abbreviate that MADE, MADE versus Montana. So you have to love these abbreviations that these groups come up with.
When I think of a housing crisis, I think of MADE. I mean, immediately.
Yeah, like I thought they would at least maybe drop the I or something so they could say like mad or, because that's what they are. So I wanted to talk about the amicus brief that we filed in that case. And then I also want to talk a little bit about what that case involves. You gave a little bit of a preview of it. So I really want to start by just giving a sort of an elevator pitch about the history of zoning, because that's the first part of the amicus brief that we filed. And I think that'll also help really put this litigation that's happening in Montana in context. And if you really want a great history of zoning, obviously there's a other podcast that we have, Bound by Oath, that is talking about that as we speak. But this will just hit some of the high notes that we talked about in the amicus brief in Montana. And so big picture, in the beginning, the status quo was essentially that people had property rights. A key reason that governments were formed were to protect property. And one of the first ways that people used their property was to build homes. And so it seems like that's something that's probably goes back to time immemorial, but it's at least several hundred years of Anglo-American legal understanding that we're talking about, where the presumption is that you can use your own property in normal, harmless ways, especially something like building a home for yourself, for your family, for other people in the community. That really started to change in about 1916. And that's when we saw the first two modern zoning codes, one in New York City, one in Berkeley, California. And if you look back at that history, you see right at the beginning, you see that zoning has this goal of excluding people really built into its DNA. So in New York City, one of the things motivating the zoning code there was excluding Jewish immigrants who worked in garment factories from basically window shopping at upscale shops on Fifth Avenue during their lunch breaks. So they wanted to get those businesses out of there so that they would leave those upscale shops alone. And then Berkeley, which pioneered the idea of single family only zoning. The historical record there shows that there was, it's not written in the zoning code. It doesn't say do not apply. But a goal there was also to keep Black and Chinese people from living in certain neighborhoods, especially more affluent white neighborhoods. And so that's coming into being in 1916. And these were, we call them modern zoning codes because, as Ari previewed a little earlier, they broke with the past in the sense that they are now comprehensively regulating what can be built and how it can be used in a way that other regulations before that really didn't regulate it in that way. So you did have land use planning, you did have regulations before that. So for example, a lot of cities would prohibit certain noxious uses like tanneries couldn't be in certain parts of the city because they might be incompatible with people living around them. And other codes around that time were also tackling specific areas of concern, especially in certain parts of the country along racial lines. And so you had restrictions on where people could live based on their race. The racial zoning was struck down in 1917 in a case called Buchanan v. Warley by the United States Supreme Court. And so these two things are kind of happening at the same time. You have the rise of modern zoning codes, and then you have the demise of express racial zoning. And so the modern zoning code really basically rushes in and fills that void with the help of the federal government. And it's really then spreading basically like wildfire after that to city after city, state after state, so that in the years following that, and then especially after the United States Supreme Court decision in 1926 in a case called Village of Euclid v. Ambler Realty, which blessed these modern zoning codes that comprehensively regulated what could be built and how it could be used, it essentially became a nationwide phenomenon starting in the 20s and moving through the 30s. So that's sort of the second phase of zoning. So you have your sort of prehistory property rights phase, then you have your 1916, 1920s phase where you have these zones, these zoning codes that are being approved constitutionally and that are spreading across the country. But they're still a little bit different than the zoning codes that we have today in the sense that they're still somewhat simple. They don't have as many different types of zones, and they're not as complicated as the zones that we have today. So the next phase after that basically is you have in the 1960s and 70s, you have another an explosion in zoning, whereas the zoning codes all of a sudden they're becoming more complicated, they're becoming more comprehensive, they're adding in more layers of public review, more hoops that you have to jump through to be able to build anything. And then at the same time, as you opened this podcast with Village of Belterre v. Is it Boras? Boras?
That's
I can
a
never
great
know how to
question.
say it.
Boras, we'll call it.
Boras. So in 1974, you have this decision, and it has just this very broad language about, what goals can zoning try to accomplish? And as you say, if you start talking about yards being wide and family values, if that's the standard that zoning has to satisfy to be constitutional, it's very close to no standard at all. There are some limits to it, but it's a little hard to find them. And so around this time, basically there is just this exponential growth in zoning and how complicated it is. And so that's the current phase of zoning that we're in, or hopefully maybe the one that we're leaving, or that we're trying to have us leave now. But that phase of the history of zoning, kind of very predictable things happened, as we've discussed earlier. If you make it almost impossible to build housing, especially housing that's especially less expensive housing, you're going to have a housing affordability crisis. If you have zoning that has basically from the beginning been trying to exclude people racially and economically, you're gonna exacerbate racial and economic segregation. There are environmental impacts. There have been studies about the toll that this places on our overall prosperity and economic growth. And then one of the things we talk about in the amicus brief is we just give a few examples from the work that IJ has done over the years to really talk about what the human toll is from having these rules in place, and this really this system where it's almost impossible to get any judicial relief from these rules because the standard is so deferential. And so that's I won't go into that part that we talked about in the amicus brief, because that's really the zoning justice initiative is really about kind of putting all those together and highlighting those. But the bottom line is just that there are real people in the real world who are trying to live their life. They're trying to pursue their dreams. And so often they're being unjustly prevented from doing so by abusive and unjust zoning laws. And so that's the background. That's the kind of history that we're laying out here and thinking about when we then turn to what's happening in Montana with this litigation. Because given all those harms that have been happening, the housing affordability crisis, environmental concerns, right? No matter where you are on the political spectrum, there was really something there for you to get behind and say, the system we know is broken, and we need to do something to fix it. And so Montana had passed these series of bipartisan housing reforms in 2023. You mentioned two of them. Accessory dwelling units were legalized statewide. Duplexes were legalized in certain cities that are a little bit larger, more than 5,000 residents. There were also provisions for allowing more multifamily housing in commercial zones. And then there was also basically a complete revamping of land use planning for some of the more populated areas that basically required them it gave them discretion, but it said, look, you need to pick some of these pro-housing reforms and you need to build them into your land use planning because you're not building enough housing and you need to do more so that housing can be built. So it was 4 key housing reforms. And then MAID comes in and they file a lawsuit in December 2023 challenging these as unconstitutional under the Montana Constitution. And they had 5 different claims. A couple of them, well, I think they were all kind of weird, but 3 stuck out as kind of especially weird. One was a claim about that it was infringing their right to restrictive covenants, where basically you just have an agreement that runs with the land that says you can't do certain things with your land. Nothing in the reforms said anything about that, so that always struck me as kind of a strange claim, but it was in there. They also had a claim about the right to public participation under the Montana Constitution because some of the processes had been streamlined. And they had another claim about taking away local power from local governments, which was also just really weird because the state constitution says zoning is absolutely, definitely 100% a state power, and whatever local power you have, it's because the state gives it to you. But they still challenge that as infringing local power. But they had 2 other claims that were just of particular interest to IJ because it's really in the heartland of the kind of cases that IJ litigates. They had an equal protection claim and they had a substantive due process claim. And those claims were really ripped almost straight out of Village of Belterre v. Boras. They talked about their neighborhoods being forced to, quote, undergo drastic and arbitrary changes in character. And they talked about that character being, quote, attractive, well-maintained yards and quiet streets, which remain safe, pleasant places where families continue to live and raise their children and enjoy the pleasures and benefits of a beautiful, leafy, and peaceful neighborhood. And in some of their filings, they talked about, they used the word dread to describe that feeling that they might wake up one day and find that there's an ADU in their nice and carefully maintained single-family neighborhood. So very triggering language if you're an IJ attorney. But they moved for a preliminary injunction for 2 of the reforms, for the ADU reform and for the duplex reform, and the trial court granted it. So my understanding is right now, unless your local government has made some zoning changes on its own initiative, is those reforms are still currently blocked in Montana, unfortunately. But because it was a preliminary injunction, you get an interlocutory appeal. And so the state appealed that preliminary injunction. And so those two reforms, ADUs and duplexes, those are currently before the Montana Supreme Court. And so that's where we filed our amicus brief. As you note, unusually for IJ, on the side of the state. But, IJ, we're about principles. So if the state does the right thing, we're going to be there and we're going to say, thank you, you did the right thing. And that should be upheld. In our amicus brief, it really focused on three big areas. The first was the history and background of zoning. And that's kind of what I talked about at the beginning, because I wanted to have that out there to kind of really see where this case falls within that history and that context. Because this lawsuit, it's really part and parcel about what we've seen with zoning for the past 100 years. And really over the past 50 years, when we've had that huge increase with the complexity and the comprehensiveness of zoning and the public participation. The things that these plaintiffs are talking about, what they're really complaining about is that they don't have, for example, the ability to complain about somebody building an ADU because they want to have their quiet, leafy neighborhood. That's really something that has been a big part of zoning for these past 50 years especially. They're complaining that they can't go to their local board of zoning adjustment or whatever the name of the board is that hears zoning appeals or variances. They can't go to those and be the loudest voices in the room and complain and get these boards to say, no, you can't build more housing. You can't build this housing because the people who live there will be not the right kind of people that we want living in our neighborhood. So this zoning is really, it's different. This case is different because they're fighting this statewide reform, but it's really parallels the kind of zoning activity that we've just always seen over the past several decades. So we wanted to really start with that history and background to understand what's happening in this case. The second part of the brief was really the kind of meat of it, which is getting to the due process and the equal protection claims. In a high level, the point that we make there is basically that they're really just doing these kinds of claims wrong. That the way they're bringing their due process and equal protection claim is not what those constitutional provisions are meant to protect. Because first, from the point of view of the plaintiffs, there's not actually any constitutional right that they're pointing to, right? So the usual case is you want to do something, you have a right to do something, and the government comes and says, you can't do that, and you bring your case and say, I want to do that, and they can't tell me that I can't do that. This case was sort of the inverse of that. The government said, sorry, we've been infringing your rights all this time, we're going to take that away, you can now go and do that. And these plaintiffs got mad and said, hey, no, we don't want to do that. Take that, infringe our rights again and infringe everybody else's rights again.
It's almost like if you think of a parallel, like in the First Amendment, if there was a censorship law for a long time and no one could talk about a certain subject, and then they repealed that law, and so your neighbors start talking about whatever the subject is, maybe, political issue, whatever, and you're like, hey, government, I have a right for you to go shut my neighbors up because you took that right away from me, and now I want you to go back to the way it was before. That's basically the same thing, but it's property rights.
Yeah, exactly. I mean, that's a great example, and I think it just really highlights what an unusual kind of case this is, because it is taking the usual type of constitutional challenge, and it is really just reversing it. And I think kind of framing it back then to property rights, the issue is that, there is a fundamental property right at issue in this case, and the Montana Constitution does list property rights as a fundamental right. So it should be protected. It should receive meaningful protection by the courts. But the fundamental property right, it's protecting the homeowner who wants to build the ADU and the duplex. It's not protecting the person down the street who doesn't want their neighbor to build an ADU or a duplex. And so they're just getting the kind of basic building blocks of this claim wrong. And another different way of looking at that is to look at it from the point of view of the neighbors. If you decide to build an ADU or a duplex, that's not violating somebody else's constitutional rights. So like, that's not something that you would think of as like, oh, my neighbor built an ADU, like my substantive due process rights have been violated. It's all around it's a very weird framing for the case. It's hard to fit into any of the normal ways that you would think about protecting these kinds of constitutional rights. The other kind of big theme that we really focus on in the brief is then, if there were a constitutional violation, what should the remedy be? Because again, usually your rights are burdened, you just ask the government to stop infringing your rights. Here, they're asking the government to actually go around and restrict everybody else's property rights and their neighbors' property rights and their own property rights. And so our view is that if there were concerns with the law, and it's hard to imagine that there actually is a constitutional problem with these laws, but if there were, the solution should be to make sure that we actually increase everybody's rights as much as possible, not that we take them away from everyone. So one of the examples we give from a Supreme Court case is if you had a law that gave unemployment to fathers, unemployment benefits to fathers, but not mothers. You can imagine mothers suing and saying, that's not fair. You're discriminating against me. The solution then is to make sure that the mothers get the unemployment benefits too. And this case is kind of more like the fathers suing because they received benefits and they don't like receiving unemployment benefits. And so they want the government to stop giving them unemployment benefits and take away everybody else's unemployment benefits too, because they just are ideologically opposed to unemployment benefits. It's sort of absurd to imagine, but that is kind of what the case is doing here. And so the court should resist that kind of remedy that impacts all these people who aren't even parties to the case. The other weird thing too is part of their complaint about how the law works is they say, well, if you really look at the law, some of the lines it draws about like where it applies and it doesn't apply, they're kind of arbitrary, or that you can do this in this city but not this city. It's just drawing arbitrary lines. Well, okay. Well, if it's unconstitutional to draw arbitrary lines, you've actually got a much bigger problem than these 4 reforms, because there's nothing more arbitrary than zoning itself, which is full of nothing but arbitrary lines. There's a book about zoning called Arbitrary Lines. And so it would be weird then to just have a remedy that actually makes the thing you're complaining about worse rather than better. And then the final concern about the remedy is just that the concerns that they're raising about the impact of the mere potential for new homes to be in their neighborhood. There's a Supreme Court case called City of Cleburne v. Cleburne Living Center from 1985, where it struck down under deferential rational basis review. It struck down a zoning decision for a group home because it was based on stereotypes and mere negative attitudes about the people who would live there. And so the takeaway of that is that decision makers shouldn't be relying on these kind of stereotypes and negative attitudes. But that's exactly what the plaintiffs were inviting the court to do here when it talks about the dread of a single ADU being built in their leafy, quiet neighborhood, and the kind of assumption that that's automatically going to clash with a well-maintained single-family home, right? Because you have single-family homes that aren't well-maintained. You can have an ADU that's perfectly well-maintained. You could have a duplex that is nicer than any single-family home you might run across. So there's just a lot of unfounded assumptions that the plaintiffs are really inviting the court to make, and that's really dangerous territory under the Constitution. So that's the brief that we filed. It was a lot of fun to kind of write that and kind of really think about how it fits in with everything else we're trying to do here with zoning at IJ. And so that was on file in May, and we are waiting to see what the court does with that next. We don't know if there will be oral arguments or not, so hopefully we will hear what happens soon, and hopefully those zoning reforms will be able to go into effect soon.
Yeah, and this is really, I think, a leading edge of a lot of the zoning reform movement, because a lot of states and cities, as I've said before, have reformed their zoning laws. California's done it a couple times. Oregon's done it. There's other examples. And I don't know if there's been lawsuits kind of this egregious. Maybe there have been some, and we haven't really heard about them because they were tossed out at the district court level. But it's a reaction you can see, because I think we've had zoning long enough now that it seems like some people, especially those who live in leafy single-family neighborhoods, just think this is just the natural state of human affairs. And so if you change it and you allow these, duplexes in a neighborhood like that, that's just not right. That's just maybe, those people are exercising their property rights, but it just isn't American. And what they don't realize is it's a highly artificial situation that's only been around a few decades. And before that, the American thing was that neighborhoods evolve. People add housing, people subtract housing, people have businesses in neighborhoods. That's just the normal state of affairs. And so I can see that as these laws are changed, people who, are maybe have been involved in lawsuits in the past about where they use the zoning laws to their advantage, like Ari was talking about, where you go to, say, a city council meeting and try to shout down a new project, and you can do that. They think, well, this is just, another way to do it, and they have to resort to these kind of wacky constitutional theories able to make that happen. And speaking of shouting down projects, Ari, feel free to add to the Montana case, but I believe you have a story about one of those.
I do, and thank you, Anthony. And thanks for that great explanation on Montana, Joe. And for those listening, I certainly commend our amicus brief to your attention. It's on our Zoning Justice Project page under amicus briefs. Joe did a phenomenal job with that. And as you just touched on, Anthony, I think a common theme that emerges across these cases is misconceptions about what these reforms would do and who is going to benefit from them. And these are legal misconceptions and practical ones as well. Joe just talked about a lot of the legal misconceptions, someone coming into court and saying my constitutional rights have been violated because I have more rights now than I did before. And that's, of course, not how it works. But there are also practical misconceptions. And one of them being, as you were just discussing, Anthony, that people think single-family neighborhoods are going away. None of these reforms are going to end single-family housing or force anyone to live in a duplex or a triplex or an apartment building, but rather what they're doing is allowing people to provide more and different types of housing options. But this is what happens when you have some fear and you inject rancorous public participation into the operation, and sometimes things go sideways. Either in the public participation process or, as Joe was just talking about, with follow-on lawsuits challenging these reforms to stop much needed housing development. But my case comes out of Philadelphia, Anthony, and it's one that does involve the rancorous public participation process that so often plagues these ambitious reform projects. They start out so great and promising and often go out with a whimper after the small minorities mobilize to shout down what would otherwise be good projects for the community. And this is kind of an example of that. This case emerges from the Pennsylvania Commonwealth Court, which I had to look up, is, along with the state Superior Court, is one of two intermediate Pennsylvania courts of appeals. So they have their Supreme Court, which is precisely what it sounds like, and they have their Court of Common Pleas, which is their trial court. But in between, they've got the Superior Court and the Commonwealth
Where
Court.
IJ has had a couple of victories in recent years.
That's right. I'm not quite sure. I'm sure there's an explanation. I'm not quite sure what the distinction between, or why you have two differently named intermediate appeals courts.
The Commonwealth Court basically takes public law cases, so about the government and some other issues. And then if it's just me suing you about a car accident, that's going to be in the Superior Court.
Oh, okay. Well, that makes a little bit more sense. So the Commonwealth Court is the fun one. That's where I guess we want to be. And this is a case involving a zoning variance, which is not always the most exciting topic, but we'll get there. A variance generally is something that's available to a property owner if the thing that they want to do with their property is a little bit different from what the zoning parameters that apply to them would allow. And it obviously varies by locality. Sometimes all you're allowed to do is see if you can build a little bit taller or a little bit wider or in the setbacks. And in other instances, you can, seek a variance that'll allow you to use the property a little bit differently than what you would be zoned for. But in any case, there's two owners who own a property in an area that is zoned single family. But the kicker here is that everything in this single family zone is multifamily for the most part. And it has been that way for 50 years.
Totally makes sense.
Yeah. And so these property owners come in, before it was a multifamily building before they bought it. Like I said, it had been multifamily for about 50 years. But the old landlord, who'd been using it as a multifamily unit with the variance, to get out from under the single family designation, accidentally let that variance expire in 2014. So, later on the building was sold. The new owners got a variance in 2016 and they were going to rehabilitate the property. They ran out of money and the variance expired in 2019. And so now you have this multifamily building that isn't getting renovated and that doesn't have its attached variance and is now for sale. So Income are plaintiffs in this case in 2020. Two people who are Asian American, which is relevant. We'll get to that later. And they come in and they buy this property in 2020. They see that it needs a lot of work. It had been sitting vacant for a few years. There were squatters. People had been doing drugs in the building. There was illegal dumping, you name it. This place was totally wrecked. So they come in and the plan is to spend about $300,000 renovating these 3 units. And if you're familiar with Philadelphia, you know that there are a lot of like row houses and low rise apartment buildings. Some of them started out as single family and had been, divided by floor. And they want to do, 2 to 3 units per building in 3 attached. And it's one attached building, but there are 3 separate addresses designated to this. So you're talking about 8, 9, 10 units max in South Philadelphia, which is what it essentially had been all along. And so they go to the relevant licensing board and they seek their permit to start this renovation. And the licensing board and the licensing and improvement board says, no, we're not going to give you this permission to renovate the property because in fact, you want to renovate a multifamily structure, but you're zoned for single family. And there was a variance that attached to this property, but that's expired. So you can't do it. And these people realize, well, this is not an economically viable project if this entire thing can only house 3 units instead of, 9 or 10. So they appeal the decision. And in the course of the appeal, they seek a new variance to allow them to have multifamily in this single family zone, which again is consistent with everything that's on this street and has been there for 50 years. And they go in front of the commission or the Board of Zoning Appeals, I should say. And one of the members of the board recommends approval. But there is some community opposition. And this is where it gets ugly. And this is often where it gets ugly. The applicants, perhaps not knowing how this could go, didn't have an army of supporters. And it's always hard to have an army of supporters when you want to do a housing reform project because you're talking about hypothetical would-be new residents who can't just show up and say, I would live in this place if you let it get built. Whereas, the existing members of the community are, of course, already there. And so this gentleman, I think his name is Bruce Baldwin, who is, a community leader on this 7th Street area in South Philadelphia. He comes in and, for whatever other work he's done for his community, I think he was in the wrong here. And he goes on what, the council for the zoning for the variance applicants described as a 20-minute tirade. And frankly, that was being kind. If you read what's in the opinion, it sounds quite a bit like a racist screed for 20 or so minutes about Asian landlords and Asian Americans in general, saying they're not going to rent to other people in the community. They're going to violate fair housing laws. They're only going to rent to other Asian Americans. They don't speak English. A lot of stuff that, frankly, we heard over 100 years ago about Asian Americans when the first zoning laws were being passed, back in Berkeley, California, like Joe was describing
It all
earlier.
comes full circle.
It does. It does. This is very unfortunate that it's happening this day and age. But nonetheless, this is another example of how this process can be hijacked and what, in fact, motivates people who are opposing zoning reforms. There was not really an objection to its use as an apartment building or as a multifamily dwelling, which is what zoning is supposed to be about, uses and not people. But instead, the objections were about the who, and that's always the big issue. And sometimes they say the quiet part out loud, and this was one such instance. So after this hearing, believe it or not, the Board of Zoning Appeals decides to actually deny the variance. And, our friends, our applicants who want to have their multifamily building here, they realize that this is unjust. Not just unjust because of what happened in that hearing, but because there was actually no evidence that the other side put into the record, at least legitimate evidence, that negated their entitlement to a variance. They said, hey, there's a standard here for when you should get a variance. We met it. We put in evidence that shows that this would be a hardship to us. This project would not be economically viable. It's consistent with the surrounding community. And it's not going to be a disruption. In fact, this is obviously an improvement from a vacant building that has squatters and people using drugs in it. So they take it up on appeal, and that's how it gets to the Commonwealth Court. And the court there basically agrees and says, this basically is a question of an evidentiary question. What does it mean to show a hardship and an entitlement to a variance? And the court looks at the same factors that the applicants provided in the hearing. They said, this is an existing use. This has been here for 50 years. There are no single family homes in this single family neighborhood. Across the street is a park, and immediately adjacent to this building is a 63 unit apartment building. And so there's absolutely nothing inconsistent about this proposed use. And they're not asking for anything beyond what would make this like the minimum economically viable use of this property. They didn't say, hey, here's an 8 or 9 unit structure. We'd like to turn it into 120 unit high rise. They said, we just want to renovate it so that it can be functional for what it basically has been for the last 50 years. And so the court takes a look at the evidence presented by the applicants, and then they look at the, air quotes, evidence submitted by the opposition. And they say, so what evidence was this court actually going on here when they decided to deny this variance? And, they can't say for sure that the Board of Zoning Appeals was, totally persuaded by the racist testimony of Mr. Baldwin. But they said, at any level, it's very clear that you considered some of it, which they said is beyond reprehensible. So the court having, reached this conclusion, they say, look, it's usually the burden is on the applicant to show their entitlement to a variance. But we're going to defer often to the findings of the lower courts, especially on evidentiary and factual questions, which is totally common, especially when you're up on appeal. But here it's quite obvious that the evidence was such that they were entitled to their variance. And so we're going to give it to them. And so, the variance was granted, and these folks are going to get to build their modest multifamily dwelling, which is, again, exactly what it has been for the last 50 years, over the objections of perhaps one very unhappy person in South Philadelphia who does not like Asian Americans, unfortunately.
Joe, thoughts on this? Unfortunately, I think other than the maybe the racial angle, this is actually, as I find it, all too common with zoning law these days.
Yeah, I'm sure in the next application, Mr. Baldwin will be a little bit more careful with his words, and there will be a different outcome. I think kind of at a high level, my thought was, if you ever wonder why housing is expensive, remember the fact that this application was denied twice. It was denied first by the Zoning Board of Adjustment, and then they appealed to the Court of Common Pleas, trial court, and it was appealed there. So then it was denied there, and so they then had to appeal again. And that's when it was finally reversed and they were able to give permission to build their home. And so how many people who want to build housing are going to take the time to apply for a variance? And then if that's denied, are going to take the time to appeal that? And if that's denied, take the time to appeal that? It doesn't sound like a pleasant experience. And so you just multiply that by however many boards of zoning adjustment or appeals there are across the country. And it's no wonder that it's so hard to build housing. And then the other thought I had is just that if we go back to the zoning history, 1926, and in the years before that, when the movement is really building up the idea of zoning as a thing, modern zoning, there was really a promise that was being made at that time, which is that this was essentially going to be a scientific process, that you're going to be doing measurements and studies and statistics, and that's why it was upheld in 1926, is because it was the idea that it was going to be this neutral, objective exercise to make the cities more livable. And 98 years after that, this is what we have, right? I mean, we don't have any planning, right? Because we have a zone that says there are no multifamily housing allowed in an area that is basically only used for multifamily housing. So there's no zoning. And then the decision is not being made based on science. The decision is being made based on 20-minute anti-Asian tirades. So, I think like the whole underpinnings of this system, like the wheels have fallen off the cart. Even if you maybe bought the idea of zoning in 1926 as an enterprise and thought that it would be worthwhile based on its promises, those promises have fallen by the wayside years ago, and it's not the system that we have now.
In a way, it kind of reminds me what these people went through, and a lot of property owners have to go through. It reminds me of civil forfeiture, because we often say in civil forfeiture, the process is the penalty, right? You get your legitimate cash taken from you, your legitimate property or whatever, and you're not a drug dealer. It's not connected to a crime. You go to court, you fight for it. Maybe if you're lucky enough to have IJ on your side, it hits the press, and then immediately you get your property back. But you have to go through all this work, pay an attorney a lot of money, usually, to get it back. You do get it back, but where are you after that? That you had to go through all those machinations just to legitimately get your property back. Here, these people had to go through all this time and effort just to keep using the property as it already is. And now they have to pour in all the money to rehab the units and everything else that they were going to have to do in the first place. So zoning, I think, unfortunately, is a part of that, no matter how scientific you think it is at the outset. So we'll close with this new zoning justice project that we have. People may be listening and think, I know an illegitimate use of zoning that I would like to push back against. And of course, IJ can't help everyone in that situation. But if they are in that situation, Ari, our leader of this project, what should they do?
They should visit our website at www.ij.org, and under the projects tab, they should click zoning justice, and that will bring them to our landing page where we describe everything that we're doing in this area, and there is a portal for them to enter their information, and I will contact them personally to discuss with them whatever they would like to report. Zoning related.
Well, of course, zoning related. Well, we will put a link up to that in the show notes, and we'll see where this goes from there. But thank you both very much. This has been a great discussion of justice and zoning, and hopefully in the end we get some zoning justice. For everyone else, thank you for listening. And until next time, I hope that all of you get engaged.